Welcome, everybody. We are here to talk about keeping your trust healthy. A lot of the concepts that we're going to talk about today are going to be a bit broad because obviously everybody's trust is different. So the thing I want to start with right off the bat is the most important thing you can do to make sure you keep your trust healthy is understand what the trust document says. Now, what does it mean to keep your trust healthy? Keeping your trust healthy means that whatever the purpose was that you created that trust, that you're preserving that purpose. So for example, if you have created the trust so that you can apply for government benefits such as Medicaid down the line, then keeping your trust healthy in your circumstance means following the rules of the trust as written and the Medicaid rules as they may change from time to time in order to make sure that when you do eventually apply for those services, if it's not right away when you're creating the trust, that you still have the protection that you intended to have when you created your trust document. If you've created a trust to hold life insurance so that it can be outside of your taxable estate to protect for estate tax purposes, well, then same thing, you want to make sure that the trust is drafted properly, but then beyond that, that as the law may change, that you're keeping up with that and you're checking in with your attorney to make sure that your documents still hold despite changes that may happen in the law. And also that if the rules of the trust, the way that we protect for these certain purposes is by drafting the trust in a specific way that has special rules in it in order to create the protection for those purposes. And so you want to make sure you're following those things. And I'm going to get into the details on each, but a few examples. But that's the idea here. What we're trying to do is say that you've created a trust. You did so presumably with a specific goal in mind, and you want to make sure that that document and the processes that you follow when handling the document stand the test of time so that 10, 15 years down the line, you still have the document that you intended to have, and you may have some changes along the way. And we're going to discuss that today as well. So what are the rules of your trust? Any client of mine has probably heard me say that a trust is not really great reading material. It's not a book, it's a reference material. We draft trusts that have a table of contents right at the beginning. So if I want to know how I distribute income and what the rules are around that, I go directly to that part of the trust. If I want to know who's in charge of the trust, I go to that section. I can know the rules of the game, just like the rules of a board game or any other game that you're following that comes with an instruction manual. That's what the trust document is. It is an instruction manual for how to handle the items that are inside of the trust. So I already mentioned a few reasons why you might have created a trust, but I'll go even simpler. Some create revocable living trusts to avoid probate at the time of their death. So for that person, an example of how to keep their trust healthy is make sure that the trust terms say what you want them to say. So while you're alive, chances are, if it's a revocable living trust, you have full control over the trust. You can take assets out, you can put assets in, you can change the beneficiaries, you can change the trustees who will succeed you. You can do anything you want with that trust. But what if 5 years after creating the trust, you realize that you want to change the percentages of your beneficiaries? Or you have a beneficiary who became disabled and is on government benefits. You want to make sure that the trust terms protect that person. You may have a situation where one of your beneficiaries is getting a divorce, and that may change how you want to leave the assets to them and whether you want to leave it to them outright or in further trust. So keeping up with not just the changes in law, but also the changes in the circumstances that you're living in and that your beneficiaries are living in will keep your trust healthy and, again, accomplish what you're looking to accomplish with that document. For estate tax planning, you want to keep up with what the estate tax laws are. Does your trust still make sense? We have some people who come in now and they have trusts that were created in the 90s or early 2000s that had specific planning for their spouse that planned around a $1 million estate tax exemption. Well, the estate tax exemption is much higher now. And depending on how that document was written, it may not be the best bet for that spouse anymore and may not be what the original creator of that document intended. And so you want to make sure that you're reviewing those documents to make sure that when those laws change, those exemptions change. 1 million back then in New York, we now have $5.93 million personal exemption. That means if you have more than $5.93 million when you die, there'll be an estate tax. But if you have less than that, it's a full exemption. And so that's a big difference from 1 million. Does the document account for that? You may have, again, like I said, be protecting assets for Medicaid purposes, to apply for government benefits, to pay for long-term care, either home care or nursing home care. And so when we get into those types of documents, we're really worried about not just how it was created and how the circumstances of your life may change, but were you treating the assets according to the rules of the trust? So for example, in that Medicaid Asset Protection Trust, there are individuals listed as income beneficiaries, and there are individuals listed as principal beneficiaries. If you are the creator of the trust, so if I am putting my assets into a trust so that down the line I can apply for Medicaid long-term care services, then I am allowed to be an income beneficiary, but I cannot be a principal beneficiary. So that means that if I have a rental property in this trust and there's income generated from that property, I can get that income. But if I sell that house, that money has to stay in the trust and I can't receive it because I can't receive principal. And so this is very important. And when you say I can't receive principal, it's not just that I can't get cash in hand. The principal of the trust cannot be used for my benefit. So we have a lot of people who come to us and they say, okay, so we have this irrevocable trust. We created it 5 years ago. We're outside of our 5-year look back. We have full protection if we should need a nursing home. But by the way, we used assets in the trust in order to pay for some things. But we didn't get the money. The money was paid from the trustee directly to pay the bills. Well, that is not permissible. And so that may be getting in the way of the government benefits actually being, the assets being protected from when you apply for those government benefits. So again, you want to make sure that you understand the terms of your document, you understand why it's written in that way. And when in doubt, if you have a question about whether or not something is permissible or not under the terms of that document, you should go back to your attorney and check and say, is this something I can do? Or am I going to be messing with or disrupting the protection of the assets in that trust and frustrating the purpose for which I created the trust in the first place? If your children, let's say, so very standardly, if I create a trust for myself for the protection of assets in case I need to apply for Medicaid and I can receive the income, I may say that my children can receive principal from the trust. So if my children are permissible beneficiaries of principal, then they could receive a $50,000 distribution, whatever it is that they need. But again, we want to make sure that we're following the laws and the rules of the trust. So if you're one child, let's say you have one child, and that child is the trustee of the trust and the principal beneficiary, then they shouldn't be distributing assets out to themselves. They should have an independent trustee doing that. That's someone not related by blood or marriage or subordinate to them. So that way you're saying there's this independent person who is approving this distribution, and therefore we're not frustrating the terms of the trust. Again, you need to look to the document though. Your document may say that principal distributions can be made by an interested trustee. So that's to yourself or to someone who is related to you by blood or marriage. An interested trustee can distribute for health, education, maintenance, and support, whereas an independent trustee can distribute for any purpose. So not only do you want to make sure that you're distributing properly, but also is the right documentation kept in the files so that if down the line we need to prove to a creditor, be it Medicaid or any other creditor, that the person who created the trust or that the trustee didn't break the rules of the trust, do we have the records that we need to prove that? That brings me to record keeping. Your trustee, whether it's yourself as the sole trustee of your trust or someone else as trustee of your trust, should be keeping records from inception of the trust. Banks don't keep records forever. They generally keep things for 7 years. So if we need to trace back and do perhaps an accounting to beneficiaries or proof to creditors of how assets were distributed from the trust and whether they were done properly, it's important for the trustee to keep their own records to prove that things were done properly in terms of the trust. Let's move to the second step of a trust. So very often our clients, for whatever purposes, create a trust for themselves while they're living, but it provides that upon their death, the assets go to a trust for the benefit of someone else. It might be for the benefit of their spouse. It might be for the benefit of their children. Let's take that same person I said who has one child, and that one child is the 100% beneficiary of the parent's trust. So now parent has died, child has a trust. We often call them in our office descendants trusts. They have a trust. That trust has its own rules. And generally what we're looking to do is allow for that beneficiary to have control of the assets and manage the assets and make decisions, but to also have creditor protection over the assets that are left behind to them. Part of that creditor protection comes from there needing to be an independent trustee to distribute assets to that beneficiary. Now, if that beneficiary has been taking money from the trust and using money for their family and very liberally doing things without the independent trustee, then take a creditor coming in, let's say a divorcing spouse, and the divorcing spouse says, you're saying this trust is creditor protected, but you've been using it to support our lifestyle this whole time. And courts look to that. They look to see how have the trust assets been used, and they continue that level of support quite often. So again, you want to make sure that when you are taking distributions from trusts, that you're doing so with the advice of an attorney who can explain to you all the nuanced reasons why you may or may not want to make a distribution in that manner. There may be a better way to make that same distribution. I think we have a question, Liz, so I'm just going to pause for a second so we can take that.
Sure, there's one question. If I update my trust, how does it affect bank accounts titled by the trust and its date?
Oh, that is great. That gets me to a new topic, which I was going to go into, so I will skip to that. So that gets me thinking about what's in the trust, funding the trust and keeping track of what's in the trust. So the short answer to that question is the title doesn't change if you change the name of the trust. So if you change the terms of the trust. So if I have the Britt Burner Trust and I make a change to the terms of the trust, and whether that's by amendment or a full restatement of the whole trust, it is still the Britt Burner Trust that holds title to that account. And so the title of the account will not change based on that. Now, that being said, you may notice that if you have a trust and that trust statement says Britt Burner Trust, and then the name of the trustee is on the statement, well, then if the change that you're making to the trust is changing who the trustee is, the current trustee, you want to make sure that the institution holding the account is on notice so that they can amend that to show the new trustee's name. But that is the Schedule A. That's what I want to talk about next. The Schedule A is the listing at the end of the trust of what assets are owned by the trust. So you can draft a trust, sign the document, and if you never take any further steps, that trust doesn't own anything. You need to next fund the trust. You need to go to the bank and put the accounts that you've decided will go into the trust. If it's a piece of property that you're putting into the trust, you need to sign a deed giving ownership over to the trust. And then we highly recommend that you keep track of what assets are in the trust on the Schedule A. That is a list at the back of the trust that you and or your trustee should keep that says bank account number X is in the trust. The real property located at and the address, that's in the trust. And then you can continue to list out what's in the trust, which will make it easier down the line when you are looking to update the trust or change the terms of the trust to see what assets are we controlling here? What are we really talking about changing? In addition to making the trust the owner of certain assets, you may make the trust the beneficiary on certain accounts. So you may have a life insurance policy that pays into a trust at your death. Again, you want to make sure that those beneficiary designations are up to date. And you may want to put right on that Schedule A or in another listing that while the life insurance policy, it may or may not be owned by the trust, but certainly make it known that the trust is the beneficiary. Again, it's just good record keeping. And that's really important in making sure you're maintaining the trust. I see another question here. Is having an only child as the trustee not a good idea? That's a good question. So I wouldn't say that it's a bad idea. And for many people who only have one child, that child is often the trustee and the beneficiary in certain circumstances. But you want to make sure that the trust allows for that trustee, the terms of it allow for that one child as trustee to appoint an independent trustee to make certain distributions if necessary, to appoint them as a co-trustee. That way, the child can be in the position of trustee, but also appoint someone down the line if that should be necessary. Also, the creator of the trust, the grantor, the parent in that circumstance, can also retain the power to add a trustee if it should become necessary down the line. So again, you want to make sure on the drafting end, the attorney should be making sure that the proper flexibility is in the trust to make sure that your goals are accomplished. In addition to, I'll answer another question. So it says, can you write into the trust that the child receive a certain amount per year because there's a concern that the child, if they receive more than that as a distribution, that they will, in the words of this person, blow through it. You have to realize potential tax implications to everything you do with a trust. So when I say that all distributions from a trust should be made, and if you have any questions, it should be done with the advice of an attorney. Quite often, you also need the advice of an accountant. Why? Because taxes have to be paid. And the question is, who pays the taxes? So if you have $100,000 and the beneficiary of the trust gets all the income every year from that trust, if that money is invested, well, then the beneficiary will pay the income tax on that with proper reporting from the trust. If you don't allow the beneficiary to receive all of the income, if you limit what they receive, which in some circumstances, because a child maybe we're worried they're going to spend too much money, they're going to waste it. Maybe they are on a special needs person who needs the assistance of government benefits that counts income. You might not want them to receive all the income. That's okay, as long as you understand that there may be tax implications in that the trust may have to pay income taxes, which are often at a higher rate than the individual beneficiary. So very often, and this is when you're creating the trust, a conversation to have with the attorney who's drafting it, what your particular concerns are with the beneficiary. But you may want to have the trust say that there's a different beneficiary than the trustee, and that the trustee has the discretion to distribute to the beneficiary as they see fit. I don't like to set a certain amount of money in most circumstances, because we don't always know how much money will forever be in the trust. We don't know how much of it will be liquid as opposed to invested. And we don't know if you may say that X amount of dollars goes out to that beneficiary, but that might not be appropriate for that beneficiary in a given year for some reason. So that is why I don't like to set a set dollar amount. It just doesn't allow for changes in the future. There's another follow-up question. Is it possible to make a potential child a beneficiary, or do you have to wait until they're born? You can provide for afterborn or adopted family members in a trust prior to their birth. You can do so. And so some people say, well, on the topic of keeping your trust healthy, well, we've had 3 more births in the family. Do we need to change our documents? And the question is, it depends. Let's read that document and see, does it allow for afterborn family members to be provided for the way that you choose? And did the percentages change? Some people come in and they have 100% to their child, but once they have grandchildren, they want to split it up a little more. They want to give gifts to the grandchildren. And so you may change down the line your wishes, not just the law change or change in your circumstances. Just your preference of what you might want to do may change over time. And you want to allow for that. Again, in the drafting phase, we try to allow for you to make these changes down the line and allow for some flexibility. For those who have what we call irrevocable life insurance trusts, or ILITs, these are trusts that own a life insurance policy, so that life insurance policy will not be part of your taxable estate. And there's certain requirements of notices to go out to the beneficiaries of those trusts. And again, you want to make sure that you're keeping up with the rules of the trust in order to make sure that the benefit of this being outside of your taxable estate, and also the premium payments being outside of your estate, not being an issue. We recommend that you review your trust every 3 to 5 years. Lately, a lot of people have been coming in for reviews because they're seeing what's happening in Washington, and they're curious if it's going to affect them or their beneficiaries, and if there's any changes that have to be made. So we've been doing a lot of trust reviews recently because of that. However, everyone should have their trust reviewed. It should not be that you wrote a trust and 10, 15, I hate to even say 20 years later, you're coming back in or going to an attorney and saying, I haven't been here in years, and now my 10-year-old is 30 and they have 2 kids of their own, and whatever else has changed. Hopefully we will have checked in sooner than that. But certainly if you haven't been in and your child has gone from a minor to being over the age of 18, these are the kinds of things that will make you want to come back in. Retirement, yours, your spouse's, moving either to another state or downsizing. When you sell a property or you sell an asset in the trust, you want to make sure that the asset is going where it's supposed to go. So let's take that Medicaid trust that I was talking about. We're looking to protect for Medicaid benefits. Now, if your trust owns your home, then when you sell your trust, you should be making sure that the proceeds of that sale stay in a bank account in the trust. That check should be made out to the trust. It should not be made out to you individually. That breaks the protection of the trust. Again, so any major event like that is something where you should be checking in with your attorney and other advisors to make sure that you're doing things properly. We talked about a change in your beneficiaries and your circumstances. You may not like one of your beneficiaries anymore, or maybe a lot of your beneficiaries have predeceased you, or it was a charity that you've kind of fallen off of wanting to support. You can make changes to make sure that your trust goes to those that you choose to, as long as the trust terms allow you to make those changes. If you purchase a new asset, depending on the type of trust you have, the question should be, I'm buying a new asset. Who should buy it? Should I buy it? Should my revocable trust buy it? Should my irrevocable trust buy it? And so if you are purchasing a new asset, you should be checking in with your attorney and your tax advisor to make sure that it's being purchased by the correct entity. And that's important. You don't want to have a revocable trust that you're trying to avoid probate, and it has all these assets, and then you buy a piece of property in your own name and it defeats the entire purpose, because at your death, we have to probate your will for that one asset. So if you're purchasing new assets, you should be checking up. The other thing that I would just mention, and this is something that if you wrote a trust with an attorney, several years ago, this may not have been part of the discussion, because this is a growing area of trust law, but it's something we call trust protectors. So very often an independent person, again, that means not related by blood or marriage or subordinate to you, is appointed in the document as a trust protector. They are not the trustee, but they're there in case certain things need to happen. So if your trust is irrevocable, but you need a trust protector to make certain changes, or to change the trustees, change the beneficiaries, put one of the beneficiaries' assets into a trust for protection, resolving disputes. If there's two trustees and they don't agree, the trust protector can be a tiebreaker. And each trust document should say what the powers are that trust protector has and what they can do. They don't have any ongoing job with the trust, but they can be called upon when when an independent person is needed in order to make changes in the life of the trust. There's a question here, should we be waiting for Washington to settle things before coming in? I would not allow the activities of the government to stop you from coming in or going to see your attorney. There will always be changes, and understanding what the potential changes are and how they could affect you potentially is important. And it could be that no changes happen, but it will have been important that you at least were staying on top of things. There might be something else that you didn't realize that had changed that you needed to come in for. So I would not wait for Washington to settle. I guess, will it ever settle? But I would not wait for that. Are there any other questions at this point? I'll give it a minute. Okay. Is someone appointed to become a trustee, or can they deny that request? So yes and yes, you are appointed. Now, I didn't discuss yet, but there are lifetime trusts, living trusts, and then there's what we call testamentary trusts. So I can appoint someone to be trustee. They can certainly decline the power they can certainly decline the right to be trustee. They don't have to serve if they don't want to. A testamentary trust is a trust created under your last will and testament through the probate process, and that actually requires court appointment. You can still decline that job, but it does require a court appointment. It also requires court appointment if a testamentary trustee is going to resign and a new trustee is going to be appointed. That requires the court as well. That's why very often when we have clients who have trusts that are going to continue beyond their lifetime for a spouse, for a child, for some other beneficiary, we often suggest this be done so in a trust document rather than a will, so that we can avoid the continuous court oversight and going back to the court for appointments. There was a question here, if we charge for reviews of trust not written by our office, and we do, and depending on the circumstance, that cost will vary. I answered that one. Someone asked what a life estate is. So if you have a trust, you may not be getting into the realm of life estates, depending on the circumstance, but a life estate is an interest that you can have in a piece of real property. So for example, if I own my home and I want to make sure that it goes to a specific person upon my death, but I want to retain the right to live there for my life, I get certain property tax exemptions, etc., then I can transfer the property. Really, I'm just transferring my death, the interest at my death, and I can retain or hold on to a life estate, which is an ownership interest in the property. And the percentage changes based on my age. The IRS actually has a table that says what percentage I own. What percentage my life estate is worth based on my age. Life estate is not always the best way to do things, so I wouldn't jump into a life estate without speaking to an attorney, because there may be a better option to convey property. There usually is. So if the property is owned by, okay. So the only property owned by the trust is an apartment, and the apartment gets sold I'm assuming at the death of the creator. The question is there any reporting to the government to conclude the trust? It's not, the only reportings that might be required to the government would be if there are taxes that have to be paid. Depending on the terms of the trust and the situation, there could be final income taxes for the trust, depending on how long after the person died the trust was in existence. There could be capital gains taxes on the sale of the property, depending on if there was a growth and again, how long the property was retained, or there could be estate taxes. So those would be the reportings that would be required. The follow-up, or a different person, but also asking about an apartment. If you own a co-op, can you put it in a trust? So the legal answer is yes, you can, but you need to check with your co-op board to see if they allow ownership by trusts, and some do and some don't, and some are picky about what kind of trust and what the terms of the trust are. So that is co-op by co-op on a case-by-case basis. And also, if you have a mortgage or a line of credit on your co-op, then the institution holding that mortgage has the original stock certificate and proprietary lease, and you need to ask their permission in order to make that transfer to trust as well. So you can do it as long as the co-op and the institution allow you to do so. And a government retirement account be put under a trust. Generally speaking, tax return deferred retirement accounts don't become owned by a trust, because that would be considered a taxable event. But in certain circumstances, and with very careful drafting of the trust, you may name the retirement account, government or not, as beneficiary of the trust, as beneficiary of the account at your death, depending on the situation. I think I answered all those questions. I'll wait to see if any others come in. So just to recap, I think the most important things to take away are understand what your trust document says and what the rules are. Keep good records of all activities from assets bought and sold and distributed and held onto within the trust, all accounts and properties. Review your trust every 3 to 5 years and make sure that there are not any changes that need to be made based on anything internal with your situation, your beneficiary's situation, or external with the way laws change. And make sure that you keep a good record of what assets are owned by the trust and what assets name the trust as beneficiary at your death. And then anytime something comes up that requires you to interpret the trust or requires you to make a distribution out of the trust that is different from something you've done before, you should be checking in with your attorney to make sure that you are following the terms of the trust and continuing towards the goal that you initially set for why you created the trust. I'm going to answer the questions as they're coming in. So what happened with my trust if I go to another county? If you move to another county, there should be no issue. If you move to another state in the United States, you will want to have your trust document reviewed by an attorney in that new state to see if any changes are necessary based on the laws of that state. And again, based on what your goals were for creating the trust. Not all trusts will need to be changed just because you've moved to another state, but a review is certainly necessary. The trust will be valid as long as it was validly signed in the state that you created it in. So the next question is, if a husband and wife both have revocable trusts, one spouse dies, does that trust become irrevocable? So when one person dies and they're the owner of a trust, that trust becomes irrevocable, yes. However, the terms of the trust will control. So this individual should have their trust reviewed or have read the terms of the trust, because it will state what happens when the first person dies. In some of our trusts, quite often in our Medicaid asset protection trust, the trust actually is irrevocable to begin with, but it continues for the life of the spouse. The spouse becomes the income beneficiary. In other cases, it might become irrevocable, but then go into a further trust for the spouse. And then how much access the spouse has to those assets at that point depends on the terms of the trust and how it was drafted. So the question is, what are the tax liabilities in moving bank accounts and investments into a trust? It depends on the type of trust. So some trusts, depending on how they're written, are what we call grantor trusts. The grantor is the creator, and a grantor trust means that under the IRS code, all income generated from that trust is considered to be the grantor's. And so there might not be tax liabilities from moving bank accounts and investments into a trust. However, if you do move income producing assets into a trust and the trust retains that income, depending on the way the trust is drafted, it could create more income tax liability because a trust pays at the highest tax bracket a lot sooner than an individual does. And so it depends on the individual, depends on the terms of the trust. So next question is, if a husband and I each have a revocable trust, whose trust would cover the assets of the house and or joint bank accounts? It's different in every case, and we would discuss with clients not just how to draft the terms of the trust, but also how to fund the trust. But quite often, if we have two spouses who have joint assets, we will have the assets be owned half by each trust unless there's a reason to do it differently. But we will often have both trusts own the assets. So the question is, in an irrevocable trust, can assets be invested? They can be invested. It'll, again, the terms of the trust will determine whether or not there's a lot of different types of irrevocable trusts. So the terms of the trust will determine whether you should do that or not, and the pros and cons. But yes, you can invest money in trust. A trust owns assets just like an individual does. So I can take my cash bank account and I can buy a house with it. I can sell the house. I can invest the assets. I could buy a condo. You can do whatever you want. The trustee can manage the trust assets within the trust. So that goes on to the next question, which should my brokerage account be in trust? It depends the type of the trust, and it depends what your goals are, but certainly a brokerage account can be owned by a trust. You just have to determine if that makes the most sense in your circumstance. Reasons not to have a trust, someone's asking. I mean, very often, so some people just don't need it. There's the way they own their assets, and what their assets are there's no goal that can be accomplished any better through a trust than through other assets. For some, they don't want to go through the process of transferring their assets to a trust while they're alive. They don't want the paperwork associated with it. And for others, they don't want the cost associated. There is a larger cost generally to creating a trust than to creating a last will and testament, because it's a lot more upfront work and a lot less work on the back end after death, because we've avoided probate. So that's some reasons why people might not want to have a trust. All right, I think we've got all the questions. Thank you so much, everyone, for joining us today. I hope you got a little bit of information that can help you move forward with the trust that you have or the trust that you're thinking about creating. And we're happy to be here and to give you this information. And I hope that you all have a great day.